On this episode of Law Weekly, we take a deeper look at some of the discussions from the just concluded National Summit on Justice 2024, jointly organized by the Federal Ministry of Justice, the National Judicial Council (NJC), and the Nigerian Bar Association. We have the views of two senior legal practitioners. Also showing on the program, highlights from the 7th Annual Conference of the International Law Association Nigerian Branch, which had the theme Public-Private Partnership and International Law, Building Blocks for Sustainable Infrastructure Financing. Plus our recap of the top trending stories in the courtrooms. Hello and welcome to the program. I'm Shola Shuyeli. Last week on the show, we brought you some of the highlights from the just concluded National Summit on Justice 2024, which held in Abuja. Two senior legal practitioners who attended the summit have been sharing with Law Weekly their key takeaways from the event and what urgently needs to be done to reform the justice sector.
We looked at the delays in the judicial process, especially with regard to civil litigation. We looked at decongesting the courts. We looked at the possibility of unbundling the courts. We also looked at the possibility of creating more avenues to access the courts. Because, like somebody said, it should no longer be that, oh, there must be access to justice. Yes, we've agreed there must be access to justice. But the question of what we should be addressing now is, once you get to court, how long will it take you to exit from the process? So we're likely to see in the amendments proposed, timelines probably for conclusion of civil cases, most especially cases that borders on contracts and sensitive transactions. We're likely to see timelines also for deliverables, that is, parties, just as you have in the arbitral process, parties, when you are expected to do certain things, penalties for not doing them, and I think those penalties will be more stiff than we have at the moment. We're also likely to see situations where cases that ordinarily not to go to court, get to court, penalties for doing so. And we're also likely to see situations where unnecessary delays will be prevented.
So with all of the issues that were discussed at the summit, did you identify any gap? Was there any issue that you thought should have been on the table but wasn't there?
It's difficult to cover everything. Most especially since I was part of the organizers. I'm a member of the NBA Justice Sector Reform Committee, and it was an idea that we do a follow-up on the first edition. I'm glad enough we met the AG. I was also in that delegation that met the AGF, and he told us that the ministry was also planning something like that. So we had to harmonize the two positions. Initially, we had thought that this second edition will be like a review session of the resolutions and the deliverables that were highlighted in the first edition. But because of the involvement of the ministry now, we had to expand the scope. And I think it is still good, especially since we now have a new administration. The last edition was done, I think, towards the tail end of that administration, 2021 or 2022. So I'm not sure they had that time to implement some of those resolutions or most of the resolutions. But with this one, in the first year, I think this administration have sufficient time to look critically at some of the resolutions and choose or decide on how to implement them.
While we await the bills that have been proposed by the AGF to the National Assembly as a result of this summit, what are the practical things that you think that we can do to speed up our justice system, make entry and exit into the justice system easier even for litigants?
Well, I think we need to unbundle the structure, especially the appellate structure. I've said this several times. I'm of the humble view that either the Supreme Court goes back to the process where they were sitting in as an assises court before. That is the process where they sit region by region. At that time, the Supreme Court goes around, the Court of Appeal goes around and take cases within that region. Or we create regional appellate structures. We have 36 states. we can have one Supreme Court, but sit in the 6 regions. Okay? Thank God the Court of Appeal is spreading now, though they haven't spread to my state, which is very painful. We can have the Supreme Court sitting in 6 regions. In that wise, now we have a full complement of the courts. Another thing which I appreciate this administration for. For the first time, most people don't know that for the first time since I think 1982 or 83, we have full complements of justices of the Supreme Court. Now, they can break into 5-5 and take zone and do it zone by zone. The challenge we may have there is challenge of that some of them would have sat on some of those cases at the lower courts. Yes. Okay, so the challenges of disqualification will come in. My recipe to that is probably we tinker with the Supreme Court Act and increase the number of justices to like 30, so as to accommodate some fellows like those who are from the academia who want to go to the Supreme Court, some senior advocates who want to go to the Supreme Court. We tinker with it, increase the number, maybe to 30 or 36 as might be appropriate, and then let them sit by zones. In that case, you would have had a mixed potpourri, a mixture of those who emanated from the lower courts and then those who are coming from outside. So administratively, the CJN will know how to do it. My second option would have been to encourage the states to have their own appellate structure. Now we can go back to the situation where states have their own appellate structures, like we have in the US and I think in Australia. You can thereafter decide, and that will involve constitutional amendments, really, because the issue of powers, jurisdiction will now come into place. You now devolve powers on those straight appellate structures to be related and limited to cases coming from their states. Because, candidly speaking, I don't see why chieftaincy tussle from my village in Erike or the local government here, we go to Supreme Court. And somebody from Yenogwa will sit over it and appreciate what is being said beyond what he reads. Unlike when you have the state appellate structure, somebody from Abeokuta, somebody from Ijebu, somebody from Remo, we know that this is the way it is done now. No, you are not telling the truth here. Okay? So we may have to look at that too. So that at the end of the day, even states who cannot afford to create their own appellate structure can merge. 2 or 3 states can decide, let us, particularly if they are close to each other, let us have our own appellate system. And we fund it. So that will decongest both the Court of Appeal and the Supreme Court considerably. So it will be matters that strictly relates to federal laws, constitutional matters, and probably matters relating to fundamental rights that will go to the Supreme Court. So in that process, we would have been able to separate the 2 jurisprudence, jurisdiction of the states from the federal jurisdiction. And where they interpose or where they mix, the law will also provide that it's the federal courts that will have jurisdiction. Very simple. So you will not have cases bordering on customary land tenure system going to the Supreme Court.
A former vice president of the Nigerian Bar Association and special advisor to the Senate President, Monday Ubani, who also attended the summit, shares with Law Weekly some of the key discussions at the summit and his suggestions for reforms.
My principal raised 3 fundamental issues I felt that should be addressed by the judicial sector. The issue of what you call interlocutory appeal on civil cases, that has been resolved in criminal cases. If you are having a criminal case now, you raise interlocutory, they won't allow you. You have to end all the substantive matter alongside before you can appeal. Yeah, and so, beautiful. So we now say, can we incorporate that also in civil matter? If you have a civil case and you have an interlocutory matter coming up, Don't go on appeal over that. Allow everything to end. Decide, let the court take a decision. Then you can now appeal if you have any issue on the interlocutory thing. At the same time, rather than stalling a matter at the lower court, and then take interlocutory matter to Supreme Court, that will take average of 20 or 30 years. By the time you come back for the re-substantive case, all the parties would have died, and even the substance of the matter destroyed. So that was a very beautiful suggestion from my principal. Then the second issue was issue of consent, of Attorney General before you can execute judgment on state government or the agencies or at the federal level. He said no, there can only be a notification. Notify him, and then let him be aware. If he has to appeal, let him appeal. If he wants to settle, he settle. But if it is Supreme Court final decision, then you just notify, and then automatically you go ahead and garnish the account and all that, which again is a very beautiful. Then issue of ex parte abuse by justices. No, he raised that issue. There is issue of his all matters from my village going to Supreme Court. They are now saying, why can't we allow state matters to end at the Court of Appeal at the state level? Why must we carry every matter to Supreme Court? That again is being considered. So there are many issues. The issue of nomination, appointment of justices, that also was part of the discussion. And the welfare of justices, which this government have started to address. Now that it's going to be enhanced salary and allowances for justices, which is clearly commendable. For over 10 years, nothing was touched in that area. So these are issues that came up, and they are in for me. But the most important aspect of this talk shop is that it's going to be followed with action. Different from all other previous talk shop we have had, where nothing concrete is being done. But this time around, there is already a drawn bill that will be sent to the National Assembly for them to consider, and then reflect them in changes that is necessary.
While we wait for the bills being proposed by the AGF, what are your own views about the process of delay in our courts? What are the practical and specific things that you think that we need to be doing to make entry and exit into our justice system easier, especially for litigants?
We need more judges in Nigeria. We are a nation that thrives in going to court to resolve issues. Even with the ADR that is being introduced, many people are here to embrace it. They still feel that the only way they can resolve issues is going to court to have those matters ventilated, and then adjudicated by a court of competent jurisdiction. So you must get more justices. Even at our Supreme Court? No, I'm talking about at the lower court now. And then create more divisions, and then employ technology. See, one of the reasons why we're having delayed trials and proceedings in court is this issue of longhand. We can't continue in 21st century. Sometimes I feel ashamed, that at this level, other nations in Africa have embraced technology in their judicial sector. So we're still using longhand to write. So that contributes to delay. We must embrace technology in our judicial sector. We must. It's something that is compulsory. It's becoming a shame and becoming embarrassed that in this age and time, we are still using longhand. So it contributes. Then get more justices, create more judicial divisions. Then there are cases that justices should manage very well. Sometimes you read the statement of claim and read statement of defense. You should be able to decide the case rather than this issue of adjournment and all that. So justices also contribute, lawyers also contribute to the long delay. So everyone is implicated. We must look at issues and deliver justice. There are cases that shouldn't linger for too long. There are some land matters you see that this man is a thief. He's trying to take over a land that does not belong, and still keep on adjourning, giving a thief an opportunity of being heard. But you can look at it and say, look, my friend, do you say you own this land? Why are the documents and all that? Documentary evidence. And before you know it, the matters are decided. But some justices are clearly not in charge of their courts, and they keep on. So it is also an issue. Lawyers also come to court over matters that are supposed not to be in court whatsoever. So disciplinary measures also must be taken against those lawyers that come to court over frivolous matters that ought not to be in court. We must deal with that. We must deal with the issue of welfare of justices also. That these people that work day and night, write judgment, must be taken care of so that they can have the heart to do these things, diligently. So we must address it. But most importantly, is the issue that not every matter must go to Supreme Court. We must stop at a level. That is how even America operates. They don't allow every matter, but constitutional matters or matters of national importance can go to Supreme Court. Not every matter from my village, as I said earlier, must get to Supreme Court. Ordinary landlord and tenant matter that should stop at a level goes to Supreme Court. So it is not right. So
was there a consensus on
yes,
that?
a consensus is that we must not allow every matter to go to Supreme Court. In fact, all state matters should end up at the state level. There must be a court, a seal at the state level that all the matters from the state, unless they are of constitutional importance, then you now take them to Supreme Court. But if not, let every matter that emanates from the state end at a certain level at the state level. Maybe at Court of Appeal, or Supreme Court of the region. You can create a Supreme Court of the region or states, as done in America, and then end them. We shouldn't be taking every matter to Supreme Court. We've been saying it over years. I started singing this song over 15 years ago. But I'm very happy now that everyone is, just as I was talking about state policing, even at that time, they were all, shouting all of us down. But the same governor that were all shouting are now agreeing that state policing. But anything we are saying, we know why we are saying it. There was a time they say, oh, radio station and television should not be owned privately. That it must only be NTA and then Federal Radio Nigeria. But today, look at channels, look everyone, they're all doing well. The reason then, if you allow them, they're going to scatter the country, they're going to create some level of disunity, they will preach religion that was. But today, everyone now does not listen to. We all listen to private. The same thing with state police. We must begin to change things and reason in the 21st century. The way we reason in this country, we are thinking backwards instead of making movement forward. Issue of fiscal federalism, we've been saying it. Allow states to control their and pay tax. And you see this country will develop.
Thanks for staying tuned. The International Law Association Nigerian branch, under the leadership of Senior Advocate of Nigeria, Professor Damilola Olawuyi, has held its 7th annual conference and 10th year anniversary of the association in Abuja. We have some of the highlights from that conference up next. The International Law Association ILA was founded in Brussels in 1873 as a learned society dedicated to the study and development of international law and the advancement of peace, equity, and justice worldwide. Unlike the International Bar Association, which is for lawyers, membership of the ILA is open to lawyers and non-lawyers who are interested in international law, including diplomats, foreign policy experts, practitioners in justice, international law departments, and students. These are the caliber of personalities gathered here in the nation's capital city, Abuja, for the 7th annual conference and the 10th year anniversary of the ILA Nigerian branch. In recognition of Nigeria's preeminent role in public and private international law, the ILA approved the establishment of this branch in Nigeria in 2014. The president of the branch, Senior Advocate of Nigeria, Professor Damilola Olawuyi, says this event provides an opportunity to reflect on the journey of the branch so far and to also map out decisive plans for the next decade.
Since 2014, ILA Nigeria became the leading platform and intellectual space for Nigerian scholars and practitioners to unearth, analyze, and resolve contemporary questions of public and private international law, international diplomacy, and global governance. This year's conference is therefore a proud milestone anniversary of 10 years since we've been doing this wonderful job of promoting Nigeria's brand of international law to the rest of the world.
The Vice President of the Association and Chair of the Conference Planning Committee speaks to the deliberate choice of the topic and the speakers.
The theme of the conference is public-private partnerships for sustainable infrastructure financing. And so our speakers cut across practitioners, lawmakers, lawyers, engineers, and people who are interested in international law and how PPP can be used as a tool for sustainable development, particularly financing infrastructure.
The keynote speaker, the special advisor to the president on PEBEC and investment, Dr. Jumoke Oduwole, spoke about the important factors for efficient public-private partnerships, PPPs, political will, solid contracts, rule of law, and stakeholder engagements. She also shared about the PEBEC Secretariat's work on the state action for business enabling reforms, which include a critical PPP framework and empowering states to establish technical PPP coordination units.
In 2024, the Nigerian economy is expected to grow 3.3% and 3.7% in 2025. This as expert analysts domestically and internationally have made these projections. And the projected success of this year's economic outlook for the nation relies on productivity and competitiveness and the contributions of businesses, which will be made possible through the improved ease of doing business, improved investment, and improved infrastructure. So it's all tied together. And as we continue to drive collaboration and deploy PPPs as tools for infrastructure development in Nigeria, we believe that as all key stakeholders play their part and embrace their roles and give feedback and continue to push on this nation-building adventure, we can unlock the immense potential that PPPs and cultivate a dynamic and prosperous business environment for Nigeria.
After her session, carefully selected panelists dwelt on challenges of infrastructure financing using PPPs in Nigeria, integrating ESGs in PPPs for infrastructure development, and integrating SDG 9 and 11 into the Nigerian legal education. The high point of the conference was the President's dinner, which featured a high-level conversation with the former governor of Ekiti State and President Forum of Region of Africa, Dr. Kayode Fayemi, who spoke about the need for Nigeria to parade the best minds at the international level if the country is to regain its place of pride in international diplomacy. And just before we go, a quick recap of some of the top legal stories in the news.
We begin with the report that the Court of Appeal sitting in Abuja has granted an ex parte application to stay proceedings in the case filed by the Economic and Financial Crimes Commission, EFCC, against the contempt proceedings commenced by the former governor of Kogi State, Yahaya Bello. The former governor had filed the contempt of court against the chairman of the commission, Ola Olukoyede, who was summoned to appear before the Kogi State High Court on May 13, 2024, to show cause why he should not be committed to prison for disobeying the orders of the court. The EFCC chairman had appealed the ruling of the trial court, which summoned him and sought a stay of the proceeding of the court. In its ruling, Justice Olubunmi Oyewole granted the EFCC's application to serve the processes in the appeal by substituted means on the former governor. The court consequently adjourned the hearing of the motion on notice to May 20, 2024. Staying in Abuja, Justice Emeka Nwite of the Federal High Court has granted the EFCC an interim order to freeze 1,146 bank accounts belonging to individuals and companies being investigated for alleged offenses bordering on authorized dealing in forex exchange, money laundering, and terrorism financing. The judge ordered that the accounts be frozen pending conclusion of investigation. While ruling on a motion moved by the EFCC counsel, Ekele Ihanacho, the judge stated that the order will be for a period of 90 days. He added that preliminary investigation conducted thus far reveals that the bank accounts are linked to persons who take advantage of the virtual cryptocurrency exchange platforms to illegally manipulate the value of Naira and laundering proceedings of unlawful activities. Justice Nwite adjourned the matter to July 23, 2024 for mention. In another suit, the Competition and Consumer Protection Tribunal sitting in Abuja has ordered that its interim order restraining MultiChoice Nigeria Limited from increasing DSTV tariff be pasted at the firm's corporate headquarters or any known address of the branches of MultiChoice Nigeria Limited across Nigeria. The chairman of the tribunal, Saratu Shafiu, who made the order, said the document should also be pasted at MultiChoice's known email addresses, social media handles, and any means of communication publicly known for MultiChoice. The interim order restraining MultiChoice from increasing its tariff was granted in favor of an Abuja-based lawyer, Festus Onifade, who is aggrieved by MultiChoice's recent announcements to increase the tariffs of its DSTV and GoTV packages effective from May 1st. In Lagos, the trial of the former governor of the central bank has been adjourned till May 9th at the instance of the defense team, following the service of additional proof of evidence on them by the Economic and Financial Crimes Commission, EFCC. Trial Judge Justice Rahman Oshodi granted the adjournment after he agreed with the defense team that the reasons given for the adjournment had merit. The judge adjourned for continuation of the cross-examination of the second prosecution witness, John Ayo, a former director of information technology of the CBN. The former CBN governor Emefiele is facing a 26-count charge before the court, alongside his co-defendant, Henry Omoile, over allegations of $4.5 billion and 2.8 billion naira fraud brought against them by the EFCC. And we round off with the report that popular celebrity bartender and businessman Pascal Okechukwu, also known as Cubana Chief Priest, is exploring an out-of-court settlement with the EFCC with respect to the charge of naira abuse leveled against him at the Federal High Court, sitting in Lagos. His lawyer, Senior Advocate of Nigeria Chikasolu Ojukwu, told the trial judge, Justice Kehinde Ogundare, that parties had applied that the matter be settled pursuant to the provisions of Section 14, subsection 2 of the EFCC Act. The counsel then applied for a withdrawal of the defense's preliminary objection to allow for the reconciliation. The EFCC prosecutor, Mrs. Bilikisu Buhari, confirmed the position as stated by the defense counsel and told the court that the commission was still considering the application. Justice Ogundare has adjourned to June 5th for a report of settlement.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program as well as past episodes. Please also send in any feedback via our social media handles. I am Shola Shayeli. Thank you for watching and see you next week.